The Supreme Court has deferred the ruling on the injunction application by Dr. Amanda Odoi and broadcast journalist Richard Delasky to the transmission of the anti-LGBTQ bill to the president and rather deliver the ruling on the same day the final judgment will be given. The five-member panel chaired by Chief Justice Gertrude Tokono stated that the court has thus agreed to make an early trial into the case as that will better serve the purpose of justice. The ruling on the two injunction application was delivered separately by the Supreme Court. The case has since been adjourned sine die. Let's go live to the Supreme Court and speak to my colleague Hansen Ajuman. Good morning to you, Hansen. Thank you for your time. Now give us details of what happened in court today and what this means.
So essentially what the Chief Justice did was to say that if you look at the arguments that have been canvassed for the injunction and you consider processes that have been filed for the substantive case itself, the two are the same, if not similar. And for the purposes of treating the injunction, the court did not have the opportunity to consider certain important information and facts or evidence as part of it. If you would remember, at the tail end of last week's, on the July 3 processes, the lawyers for the Speaker of Parliament sought to tender in what they described as the opinion of the Speaker of Parliament under Article 108 of the 1992 Constitution. But the court indicated that they would only allow him to file it at the consideration of the substantive case because in the opinion of the court, it was unfair to the Attorney General who had argued extensively on the fact that that opinion had not been delivered and was not before the court. And considering all these, the court believed that while they are considering the substantive case, all these issues that initially were excluded from the injunction application will be brought to the attention of the court, and at the end of the proceedings, the court would have gotten a better appreciation of the issues to give a better judgment on the substantive case and also a better ruling on the injunction. And to help matters, the court says it has the powers to expedite trial and to order an early trial. Essentially, what that means is that certain statutory actions that may be required of the parties will be dispensed of with by the court. So, for instance, if a process is filed by the plaintiff and the respondents, perhaps per the processes, have 2 weeks to respond, the court may now ask them to respond in 1 week. Or if the court asks the parties in the suit to apply for a certain thing, which per the rules of court are supposed to be applied within a certain specific number of days, assuming for 5 days, the court reserves that right to say that you don't need 5 days to apply before we can hear. Even if you apply today, we can hear your matter. So basically, that's what the court means by an expedited trial or an early trial into the matter. What this leaves is what happens to the bill which is before Parliament, which the court already has, which the President already has indicated to Parliament not to transmit because of the impending application. Because what has happened today is that the court has not told Parliament that they cannot transmit the bill. Neither has the court told Parliament to transmit the bill. However, when we spoke to the lawyers in this case, their understanding, particularly lawyers for Richard Delasky and the Attorney General Godfrey Yeboah-Dame, the understanding essentially is that if the injunction application has been duly filed, then there's a certain expectation on the part of the other party, here the Speaker of Parliament as well as Parliament, not to transmit the bill to the president for consideration, either to assent same or to transfer to the Council of State for advice, or to send it back to Parliament with reasons why he cannot assent to this. So even though the court has not given a ruling on the injunction application, it is the expectation of lawyers for the plaintiff and the second respondent that the bill will not be transmitted to the president, which they were seeking to do anyway by this application that was brought to the court.